Well, live look at Parliament Hill in Ottawa this hour. With a court-imposed deadline looming, a new law expanding Canadians' access to medical assistance in dying is now in effect. The Senate yesterday passed a revised version of Bill C-7. The legislation received royal assent last night. The CBC's Janice McGregor is tracking this development. She joins us this morning from Ottawa live. Janice, a complex issue breaking down. Let's talk about the changes that take into effect in this legislation.
Yeah, because it's true, John. You know, our medically assisted dying law really seems to be evolving in stages. Yesterday marks the end of another stage. Canada's laws have now been brought into compliance only a week before kind of a final deadline set by the court, but brought into compliance with the Quebec Superior Court ruling that found that it was unconstitutional to prevent people for whom death was not reasonably foreseeable from access to a medically assisted death. So with this law, they do have access. It is subject, though, to some particular checks and balances designed to make sure that the bar is high for situations where it could be used, trying to ease the minds of the disability community who feared that they could be pressured into doing something they don't want to do. So there is a 90-day mandatory waiting period. 2 different medical practitioners would need to sign off. And there is a requirement for counseling and other support to be provided to these people, making sure that a medically assisted death is only seen as sort of an option you would use when you have no other options. I want to show you something that Justice Minister David Lametti said on social media yesterday. He was tweeting that a lot of people were anxious to see these changes become reality, acknowledging this had been a very long process, and he was pleased the wait was over. But he also said that it's important that all Canadians have the same respect and dignity, access to the same autonomy and freedom of choice while protecting the vulnerable. Again, an acknowledgement that there are still a lot of fears here about what this expanded access might mean for people who feel they are at risk. Important to note also that the changes in this law did not stop with complying with that aspect of the court ruling. They also removed some barriers for people who were already eligible, people for whom death was foreseeable, making it easier. For example, they don't need to be able to consent right before the procedure anymore. That was a fear for people whose conditions were rapidly deteriorating. They have removed some other requirements about a waiting period and so on, trying to, for that group of people, make it even more accessible. And of course, the clock starts ticking now on a 2-year period that the Senate kind of proposed, until perhaps this being available to people with mental illnesses, not just physical illnesses. Now, the intent is to use this period to put in place a very strict regime to make sure that this is kind of an option of last resort. Again, that people with mental illnesses would have to prove that there was no other way to relieve their suffering, setting the bar very high here. A lot of people concerned about potential abuse. Again, people feeling pressured to take this option. But we sort of kick off now a period with the clock running where they believe, because there is a serious risk that the courts could someday strike down that ban too, on access for people with mental illness, that this is now something that lawmakers need to deal with as well.
As you say, Janice, it's complicated, it's evolving. What are we watching for next?
Well, when they brought in the first law, you might remember there was a requirement for a big parliamentary review of the entire thing. Now, with the passage of C-7, we now know the format that's going to take. There is a requirement for a joint House of Commons and Senate committee to do this review. It will start within 30 days. So, you know, the one debate ends, another one basically begins. They need to report back within 1 year. And this bigger review could consider not just kind of revisiting the issues that have come up until now, like I was mentioning around people with mental illnesses, what checks and balances you need to get in place for that, but also other things that this legislation that just got royal assent didn't do. People still want to see more consideration for advanced directives. There's a lively debate about that and whether that's a good idea or not. People with dementia wanting, for example, to be able to say in advance at what point they would like to have a medically assisted death. Another issue, mature minors. Is there a way that the law could allow an older youth, someone under 18, to reasonably give consent if they felt their suffering was intolerable? That's another place Parliament has not gone yet, but some think it may need to eventually go. So tough issues here, a lot more to discuss.
Thanks for this, Janice. CBC's Janice McGregor, live in Ottawa.
Most welcome.